We're here today with Charles B. Ticker, estate mediator, estate litigator, and I have a question for you, Charles. The question is, what should we be looking for in a mediator? Let's say, we're going to sue our brother or sister over dad's or mom's cottage, and what do we look for in a mediator? What are we looking for?
Well, if you're talking about mediation of an estate dispute, one of the first questions you have to ask is, do you want a mediator who specializes in estate matters, who's had a lot of experience dealing with estate disputes? Do you want a mediator who's more of a generalist that does various types of cases? Do you want a lawyer versus non-lawyer? Do you want a retired judge? What sort of style of mediator? There's lots of things that go into the decision-making process in terms of choosing a mediator.
Okay, and let's say we do decide to go with a, well, first of all, you said retired judge. Is there what are the pros and cons of choosing a retired judge?
Well, I think the reason that people will want to use a retired judge is being a former judge, that certainly brings a lot of credibility to the table, and obviously people are going to pay close attention as to what a judge thinks about the merits of your case. And quite often, lawyers, when they're planning a mediation, will consider a retired judge where they feel that that is what's needed to get the parties to move towards settlement. Maybe they need to hear it from the judge, because clients say they want their day in court. Well, this is like having your day in court, except you're not in court. The judge is not there with any decision-making powers at the mediation, but the judge brings a lot of experience and to the table, and people will sit up and take notice if the judge says, well, I think you've got a problem here with your case, and have you considered this? Or the judge might say at the mediation, when I was trying a case like this, I might be looking at it this way. So that's the pro, but there's a con to that as well, in the sense that if you jump in my view, if you jump in too early with your opinion as to the merits of the case, or if you come on too strong with the participant, they might get their backs up and stop listening and saying, I want another judge. I want the judge in court. So, but a lot of retired judges are going into this field of mediation. A lot of sitting judges are now doing it as part of the judicial process, as part of the called judicial mediations. It's like a pretrial settlement conference, and a lot of judges are getting very skilled at this because they're doing more of them. So it's like anything else. There are going to be some retired judges that are going to be excellent mediators. There are going to be others that maybe are not the right fit for the mediation. But they tend to be, well, we'll talk about maybe the styles of mediators later, but when you retain a retired judge, they tend to weigh in with their opinion more often than not. And that's
more of an authority figure there. Yeah.
Right, and that style may be the right style for your case. It may not be.
Okay, I'm going to ask you about the styles in a minute, but just before we leave the who, what about how do you decide whether you want a lawyer or a layperson mediator?
Well, in my experience, at least in the jurisdiction where I practice, typically for estate disputes, you're seeing a lawyer or a retired judge as typically the person of choice in terms of background.
Right.
So, but there are many excellent mediators that are not lawyers, but have a lot of experience and training as mediators. And there's no reason why they couldn't mediate an estate dispute. But the trend that I see, at least in my jurisdiction, is people tend to go with either active estate litigation lawyers or former estate litigation lawyers and retired judges.
Okay, and so this question of generalist versus specialist, do we want an estate lawyer, or could any lawyer act as a mediator?
Well, I think it really depends on the case. A lot of people want to go with a specialist or someone who's had experience in the area of estate disputes because they'll be familiar with the law and you know, don't have to really spend a lot of time getting up to speed on the issues. Once again, though, once you get into a specialist, the specialist brings their own biases and their own understanding and views on the law to the table. And maybe sometimes looking at the case, and even though mediators shouldn't really start going in and saying, well, you know, there's this issue that, have you thought about that? Rather just deal with the issues as they're framed. A specialist is going to tend to maybe go that way because of their experience. A generalist who does various areas of law, but has done lots of mediations and is skilled in getting the parties to negotiate and to come to the table can be just as effective, in my opinion.
Okay, well, thank you very much for that. So you alluded earlier when you were talking about whether, you know, we should choose a retired judge or a non-retired judge or not. You alluded to the fact that sometimes they tend to be, you know, act more like an evaluator or an authority figure, kind of more decisive. And you alluded to there being different styles of mediation and different styles of mediators. Can you talk a little bit more about that?
Yes, there are different styles. You can have mediators who use a facilitative approach. You can have mediators that use who tend to use more of an evaluative approach, and there's also mediators that use what we call a transformative approach. Facilitators tend to not weigh in with their opinion. They basically are just there to facilitate the discussion, to get the parties to express you know, their interests and what their motivations are, and to build the trust with the parties and get the parties to basically, you know, make a deal and basically nudge them along. A mediator who is more of an evaluator, using evaluative approach, is going to weigh in and start expressing opinions of what they think the case, what the strengths or the weaknesses of the case are, or how the case may pan out at court if it goes to trial, and may be, you know, not be shy to express his or her opinions on the merits of a party's position.
Right, and then the third one?
The third one was the transformative approach. And, you know, I was just thinking, rather than trying to explain what I talk about it in my recent book, Bobby Gets Bupkis. Sorry, thanks for the plug there. But anyway, I talk about the different types of mediators. And so if I could just read from my book, but in the transformative approach, the mediator consciously tries to avoid shaping issues, proposals, or terms of settlement, or even pushing for the achievement of settlement at all. Instead, the transformative mediator encourages the parties to define problems and find solutions for themselves, and endorses and supports the parties' own efforts to do so. So that's what I wrote in my book, Bupkis.
It sounds a little bit available at your bookseller. No, it sounds
available
a little
on Amazon. And anyway, I know when I'm mediating,
sounds a little bit like the first one, the last one.
It is, but it in the sense that it's basically not, you're not even there talking about settlement. You're just sort of like getting the parties to figure it out on their own, as opposed to when you're a facilitator, you're sort of like reminding them, you know, if you don't settle, what are you looking at? You know, what's your best case scenario?
Sounds very Zen. It sounds like people should be like doing on yoga mats and kind of with the transformative.
Yeah. So I think all mediators probably use a combination of styles. I know my style is more of being a facilitator, although if the parties are getting bogged down, and I think that there's a chance with a little coaxing that maybe they'll be able to make a deal, I'll weigh in with my opinions. Usually I'll ask them if they want to hear from me, but sometimes I won't wait, and I'll go in and let people know what I think their possible problems are with their case. And we'll do this of course, privately with each party. So you can be in one room telling one party, you got a problem here, and you go next door and say, you got a problem here. And
sounds like a movie.
Yeah, and I think that's one of the great things about mediation is that it is confidential. I mean, obviously, you got to sometimes move the parties along. I mean, obviously, you're not going to tell them something that is totally wrong, but every case has its strengths, every case has its weaknesses, and that's why cases settle, because it's the uncertainty of the outcome at trial. If everyone thinks, well, I can't lose, and one of the
they can
and this is where the lawyers can be helpful to explain to their clients that every lawyer's had a case that they thought was a sure winner and they lose, and every lawyer's had a case that they thought was a sure loser and they win. So you never know what's going to happen at court, and we stress that at every mediation.
Okay. So I have another question for you, and it's kind of related to what you were talking about before, but like, where does psychology play into all of this? Like, what the dynamic between, often these estate litigation matters or other matters, I mean, could be family mediation, whatever it is, but they involve, family members. Where does psychology play into all of this, and how does it all work?
Well, in sibling fights, estate fights, and other family members as well, there's no question that there are underlying emotional and psychological issues that go way back to when they were, playing in the sandbox. And every estate litigator can tell you stories about how this plays out, and people are reliving, when they were a kid, their sibling, threw their pet out the window, or broke one of their favorite toys or whatever, and they bring this up 50 years later, like they just never forget it. So there's no question, like the Smother brothers, and always used to say, mom always loved you best, liked you best. And these issues play out in estate disputes, so you have to sort of be obviously very keen to those issues. So you got to be part psychologist, part social worker. And these are not like business disputes. So these are disputes where people, yes, they're fighting over money, but money is basically sometimes a substitute for just an expression of love from the parent. I didn't get as much, mom didn't love me as much. And so there's no question that psychology is a huge factor in these disputes.
So should you look for a mediator that maybe has a bit of background in psychology, or what? I mean, do you have?
Well, I think mediators or lawyers that tend to go in this area typically have either an interest in psychology or a psychology background. I mean, I have an undergraduate degree in psychology. And at the time when I got it, I didn't think I was ever going to be a lawyer. I wasn't thinking about it at that point, but I was always interested in psychology. And I think it's like anything else, that lawyers are working in an area that they have some sort of personal affinity with. If someone who wants to do corporate law, they probably just going to run when they hear about a sibling estate dispute, because it's just not, their cup of tea. So I think a lot of lawyers that do this kind of work, or matrimonial law, have to have a certain type of personality that works. And what I try to bring to the table is not to be judgmental. These parties are being judged all the time by their siblings, by their family, and one of the biggest compliments I think I've ever had was someone said to me, well, I finally had someone who listened to me. So,
Wow.
So yes, you're almost like the psychotherapist there. Obviously you can't be there giving counseling, but a lot of times they're just looking for someone to talk to and to get it off their chest, so to speak. And also part of our role is working with the lawyers, because if the lawyers take the wrong approach at the mediation, if they become too combative or aggressive in their approach, and it's a very delicate underlying psychological issue, that can derail the whole mediation. So part of our role as mediators is to not only work with the parties, but sometimes work with the counsel and make sure they're not sabotaging
Are the lawyers always there, or do you ever do mediations without lawyers?
In my experience, I've always done counsel mediations where the clients are represented by counsel. There's nothing to say we couldn't do a mediation, or I wouldn't do a mediation where someone is self-rep, but I'd be hesitant to do that because as a mediator, you can't give legal advice to the parties. So
right.
If you have someone who's not represented by counsel, they probably should get legal advice before they sign any settlement agreement.
Right,
So
right.
I prefer to have lawyers, clients represented by lawyers.
Okay, Charles, I just have one last question for you, and that is, I mean, because we opened today asking what should you look for in a mediator. So I guess to close it out, the question is, who chooses, who decides, who makes the decision about who will be the mediator for a particular matter? Is it the client themselves, the parties, which client, which side, or the lawyers? How does that all work?
Well, typically the process is that the lawyers will put a few names out there that mediators that they're aware of or that they've worked with, and typically the parties through their counsel can agree on one or two choices and narrow it down. And the clients typically won't know much about mediators or their style or their track record, but the lawyers do. And getting the advice from their counsel, they'll typically, go along with their counsel recommendation. If they're, I've never had as a litigator, I've never had a case where we couldn't agree on who to choose, because there's a number of mediators out there that people have worked with. I guess at the end of the day, if there's a real problem, you can't select someone, you'd be in front of a judge and have a judge appoint a mediator.
Okay, well, thank you, Charles. This has been great. I'm sure it'll be super helpful for any party, any lawyer trying to decide, whom to choose as a mediator. Thank you very much for your time.
My pleasure.